that's the first place I wanted to show you if you need a resource. When do the rules take effect? They take effect on August 17th. That's when we have to be in compliance with the proposed settlement. Now, the court won't hear the proposed settlement until November 27th, right around there. But the judge who's in charge of it has already seen it, and he's already made comments that he likes it. So there's every indication it will be accepted. The biggest effect that we're going to see here is the compensation will no longer be on the MLS. Can no longer be on the MLS. It can't be in agent remarks. It can't be as an attachment. It can't be on showing time because all of that is done through the MLS. Now we can have it on our own website, which can show the compensation. And I was reading, you can actually put a link on the MLS. I don't know where it's going to be yet, where they can click on that and go to our page for your listings to see what the compensation is. Still don't know where that's going to be. HAR is also looking at sellers' contributions, a yes or no. That's what they're doing in California. So we're just waiting to see where they're going to put it. Where's it going to be attached? Yes, sir. No amount, just yes or no. Yes. Well, we can do it here at our office, and it's already set up on the Memorial Agents Only. You can go in there and put your listing and put what the compensation is. That is acceptable. We just can't do it for all of KW's because you can only do it for your brokerage. It'd been really nice if we were able to.
Mitch,
Yes.
can you get a microphone for the questions being asked so that the ones of us that are doing it through Zoom can hear the question?
Okay.
Thank you.
You're welcome. He was just saying that, what were you saying? You can't have any amounts for compensation on anything on the MLS. And for the seller's contributions, that cannot have an amount on it either. It's more or less going to be a yes or no. Okay. It is also a requirement that before you open a door, you must have a buyer's representation agreement. No big change because that's been the requirement here for years. I know probably hasn't been done. What is NAR's policy on steering buyers based on compensation? This has come up a lot lately, that if you call a listing agent, what's going to keep them from saying, well, I like working with you, but I don't like working with him. So I'll offer compensation here, but not to him. You just happen to be sitting there. And it all goes back to our code of ethics. If you have it on the listing agreement that X is shared, then it needs to be shared. Let me be honest and truthful.
Sorry, I have a question.
Yeah.
So I have a client who will be going a listing during this time. And I've explained the process to them, but is a seller allowed to, I'm trying to get them, to tell them what their options are.
Right.
And her option, she wanted the option that she wanted to offer compensation based on the amount of the offer. Is there any way in the agreement to do that? That's not steering, but
no. When we get to that page, let's look at it. I believe there's a line where you could put something similar to that.
I've read all the stuff that says that there can't be like a variable, and I understand that, and on the buyer's
On the
agreement,
buyer's
I didn't
side.
know on the listing side if there's a variable.
You
Okay.
can.
All right.
With this, a realtor can do nothing that puts their interest or another agent's interest ahead of the client's. So we cannot, how'd they put it? Coerce a seller to offer compensation to a buyer. And we can tell them the benefits of it. We can, tell them why it's so important for a buyer's agent to be on the other side. Best practice change requiring written agreements with buyers is triggered by touring a home. What does it mean when you're working with a buyer? It's intended to distinguish MLS participants who provide brokerage services to a buyer, such as identifying potential properties, arranging the buyer for a tour of the property, performing or facilitating negotiations on behalf of a buyer, presenting an offer by a buyer or other services for a buyer. Participants who simply market their services or just talk to a buyer, like at an open house or by providing unrepresented buyer access to the house, don't have to have a buyer's representation agreement. And with this scenario, working with a buyer, I think that's the next question. Yeah. Provide a live virtual tour. When the buyer is not physically there, you still have to have a buyer's representation agreement. It needs to be signed before you open a door. And this does not cover commercial properties. So it's any residential property 1 to 4.
Mitch, I have a question.
Yes.
Would you go back 2 slides? Talking about the practice change requiring written agreements with buyers triggered by touring a home.
Mm-hmm.
I don't know about you, it may not happen at your desk, but like even yesterday, I'm getting brazen buyers calling me going, hey, you've got this listing. I want to see it. I'm unrepresented. I don't want to work with a real estate agent. I want to do the legwork on myself. Can you go over to the house and open it for me so I can see it?
Yes.
Okay. I'm like nuts. Okay. And telling this person, and he goes, oh, by the way, send me the seller's disclosure and, all this jazz. And I'm going, wait a minute, that's representation. So we need to be very careful, right?
Well, you're the listing agent?
Yes.
If you're acting on behalf of the seller, you do not have to have a buyer's representation agreement. So your fiduciary all goes to the seller.
But I mean, if I start handing this dude, this rogue buyer, seller's disclosures and getting him all that information, I'm crossing the line, right?
Well, no, given a seller's disclosure is required by the state of Texas. So as a listing agent, the seller must provide that. If he gets serious and you're having a substantial communication or conversation with them, you're going to want to do an IABS and disclosure of relationship, saying that you do not represent him, you represent the seller. And then he could do everything. He could pull the 1 to 4 contract, he could fill it out and send it to you, and you negotiate on behalf of the seller. Okay,
but I don't have to be worried that I'm crossing the line of representation if I get him the seller's disclosure.
Right.
He might ask for other things on there like HOA docs.
That is something he can fill out the addenda to the contract for HOA.
Yeah. I'm just saying this is what I'm getting hit with. Okay. Thank you.
Yeah. Just as long as we don't give them any advice, we don't do a CMA for them unless it's the exact same CMA you did for the sellers. That's it. They ask you how long for an option period. You can read them the paragraph. A lot of times when you get to that point, they realize they probably want to be represented. Does that answer your question?
It answers the question. I still don't like this dude, but I will go on. And thank you.
Okay. You can send them I'm sorry.
I have a question regarding that.
Okay,
If my seller has said, I would like a 7-day option period, no more,
okay.
and I have an unrepresented buyer,
Mm-hmm.
say, what do you want for the option period? Do I tell them 7 days or do I say you need to figure it out?
Well, if that's the requirement of your seller and you got that in writing, yeah, you can tell them that.
Okay.
Mitch, I have a question, please.
Just a second. Go ahead.
Writing that you could share the CMA.
No, it's already in writing on the listing agreement. She was asking if you needed in writing to share the CMA and let's see. 3. Doug just fell out of his chair, so no, the sharing of the CMA is already in the listing agreement. Okay, go ahead, Sharon.
Thank you. So when representing the seller, if the seller indicates that they only want pre-approved buyers to come in their house and someone's unrepresented, how do we handle that?
Do you follow what the seller tells you? So you can tell that unrepresented buyer, sellers require pre-approval.
Do we have to have it in writing from our seller?
Yes,
So we just need to check a lot of boxes, ensure that we have everything in writing, all the various scenarios that we can encounter with a buyer, and just have all that in writing.
Yep.
And present that.
Mhm. And we'll look at that form. Yes, sir. If
For example,
yeah,
you're the seller, why would you let you come in the seller's house if you're not pre-approved, you can't buy it? I'm on the assumption that you can't buy it,
right.
but it has to be, was it in writing before?
It wasn't in writing before, but we always had buyer agents that brought them 9 out of 10 times. Now, if the seller says, I don't want anyone in my house without a pre-approval, yeah, you get that unrepresented buyer, you can ask them for it.
Gotcha,
That's another benefit of having a buyer's agent on the other side,
gotcha, okay.
talking to your sellers.
Mitch,
Yes,
can your seller request that anyone entering their home be represented by a buyer's agent or not?
that would be tricky. The first thing I think of is fair housing.
Okay.
Yeah. What should I tell home buyers and sellers they need to know about these changes? If you're a buyer and your agent is using the MLS, you will need to sign a written agreement with your agent before touring the home. We just talked all about that. Written agreements are required for both in-person, live, and virtual home tours. You do not need a written agreement if you're just speaking to an agent or buyer or anyone at an open house, or you're representing the seller only. Agents' compensation for home buyers and sellers continues to be fully negotiable. Hasn't changed. It's always been like that. They have said that it has to be conspicuous language in the agreements, and you'll see with the changes, it's bolded. When finding an agent to work with, ask questions about their services, compensation, and these written agreements. When you're talking to sellers or anyone out there, good advice.
Now, Mitch, question, it's me again. Up here where it says written agreements are required for both in-person and live virtual home tours.
Yes.
Okay, so this dude calls me and tells me I have to show him the house.
Mm-hmm.
Do I need to get a buyer's rep from him?
If you're the listing agent, no.
I understand about open houses and stuff.
Okay,
All right, thank you.
Mike. You have a question?
I don't know how to ask this, so.
Sounds like that one's dead.
So we are showing the listing
Mm-hmm,
to an unrepresented buyer.
mm-hmm.
we're having him sign the broker information.
If you're having a
Saying that
substantial
you are
communication with
not-
them, yeah, IABS.
You are not representing them,
Mhm.
but you are showing.
IABS disclosure of representation. Okay, that's best practice always. If someone's coming in, they want to see your property and they say they're not represented or they're represented and their buyer's agent's not available. IABS is always best and disclosure of relationship.
And
Mitch-
with that, Mitch,
Yes,
if I ever have a dude come through that says, oh, I don't want to sign it, then I have him initial it on the page that he's refusing to sign it.
the IABS,
Yes,
yes,
I'm just saying.
yeah. And
Yeah,
I've never asked anyone to sign an IABS. Would you acknowledge that we reviewed this? Just sometimes verbiage goes a long way.
And if they still refuse to
you can just-
acknowledge,
You can just document that it was given on such and such date and follow up with email with it attached works great. So you're
if they've
showing,
given their email address.
right, well, then you just document on there that they refused to initial, present it June 20th. Client, not client, they refused to initial, however you want to write it, just so you're documenting that it was given.
Okay, thanks.
Can I ask a question?
Yes.
Hi, so is there any reason why, sorry, we could not put in the listing agreement that if there was an unrepresented buyer, that our listing fee would change with the seller and go higher?
Yes, we'll talk about that when we look at the form.
Okay, which form? Because I want to get that form.
The listing agreement, the 1101.
Is there a new
I'm
one as
sorry.
yesterday?
No, it's the same one as of yesterday.
Okay, thank you.
All right. If you want to get more information, you can go to competition.realtor. That's going to take you to the NAR site, and they've got frequently asked questions, a bunch more information. Okay. All right, if you go to Texas Association, sign in, legal and ethics form changes. View adopted form changes. Here are the red lines. These will be put out to the public on Monday. So as of Monday, we'll start using them. With that though, since it's not going to go to the public until Monday, that means it's not going to be sent to Dotloop or DocuSign until Monday. And then they have to map them and upload them. So I would give it a day or so. They're all aware of it. And UpTech Pro that we work with, I was talking to them earlier and letting them know these will probably be dropped Monday early. So they're going to have people on it to get them into our templates and mapped correctly. Yes, use the mic. This Monday. Well, they're on here already. All right. So we're going to look at the residential buyer tenant representation agreement.
I have a quick question again.
All right.
I have a listing that hasn't gone live yet.
Mhm.
And we've already just signed the documents. Do I need to redo the listing agreement?
There is an amendment for it.
Okay, thank you.
Okay. And these, if you really don't have to do an amendment to the buyer's rep or the listing agreement unless they're not under contract by August 17th. That's why they're putting these out early. So hopefully we'll have everything sold in the next 8 weeks.
Did you say sold or solved?
Sold, closed. Yeah. Well, once they get these on Dotloop, DocuSign, the old ones will be gone. So if you pull up a new one, it'll be the most recent. Use the mic.
For prevention, we probably need to do these forms.
Yes.
Just right at the bat. That would be
Yes.
the best practice, right?
Mhm.
Okay.
Well, as of Monday or
Tomorrow.
Tuesday, only be the forms that'll be available.
Awesome. So for buyers, let's say, just try to get this form, even if you get them like this weekend or so, or doesn't matter if this is like, yeah,
Right now, you don't have access to it.
that's the question. Yeah.
Yeah,
So it's not like I can have them sign the new representation forms. but as soon
there's
as
an
we get it,
amendment to it after Monday.
After Monday. Okay,
Yeah,
okay.
after Monday.
Awesome. Thank you. Thank you.
All right. The buyer's representation agreement. This is the 1501. Let's look at the changes. Parties haven't changed. Market area, they've just clarified it a little bit. Be specific. For example, insert property address, subdivision, city, county, zip code, putting in there Houston and surrounding areas. What does that mean? Well, surrounding says touching. So be specific. And this is a place where you can start to negotiate with someone who's not willing to sign one. You could put an address in here, 123 Main Street. So when they want to see that property, that's the only one you're representing them for. Or you could put 2 addresses, whatever it may be. Paragraph 4, the term.
Oh,
begins-
Mitch, sorry. Mitch, on
Mhm.
that area,
Yep.
like I've got people right now, they're looking all over. They're looking in Oak Forest, they're looking in Meyerland, we're looking at Sharpstown. You know, I've got
Mhm.
addresses all over the place.
Put Harris County then. All of those are in
Okay.
Harris County.
Okay, that works.
Yeah.
Thank you.
And then they changed commences to begins. Another place. So they want to see properties this weekend. You could put the date. June 20th through June 22nd. So doing that term is when you're representing them. And you can always amend the representation agreement if I decide I like working with you and you like working with me. You can amend it, but to get it signed, those are 2 areas you can start to negotiate a little. Any questions about those? Hasn't changed. Paragraph 7 is what is changed, and you'll see biggest change is that they took it from paragraph 5 and moved it up. All right, so broker's compensation is sharing the compensation is between brokers is not set by law nor fixed, controlled, recommended. This is the statement that's always been on there, but it had to be conspicuous. So it's bolded and underlined now. Broker's fees, when earned and payable, client will pay broker blank percentage of sales price or a flat fee. For leases, same thing, blank percentage 1 month or % of all leases over the term or a flat fee, however you want to negotiate it. Source of compensation, just move to paragraph. Source of compensation, broker will seek to obtain payment of the fees specified in paragraph 7A, first from the seller, landlord, or their agents. And then in bold, if such persons refuses or fails to pay broker the amount specified, client will pay broker the amount specified less any amounts broker receives from such persons. It's earned and payable, and the client enters into a contract to buy or lease a property in the market area, or if the client breaches the agreement. Payment, the closing of the transaction to acquire property, client breaches the contract, client breaches this agreement. It's the same paragraph we've always had.
So Mitch, we can still have that paragraph that if they fail to pay it, you will pay it, but we'll seek to get compensation from the seller. So the rule is just to keep us from advertising, we're getting it from the seller matrix?
Well, on the MLS is what is keeping us from advertising.
Just not advertising on the MLS, they're not stopping us from getting it, just can't
No.
advertise.
No, they're not stopping us from representing buyers and getting paid. It's just they wanted buyers to know upfront what we're offering and how much our compensation is. I was thinking about it like going into the grocery store and you pick everything you want, but there's no prices until you get to checkout.
Right.
And all of a sudden you get the price. Acquisition of brokers listings, intermediary client acquires a property listed broker, any compensation broker offers to other brokers in the listing agreement with the owner will be credit towards broker's fees. So it's the same as paragraph B. We're going to take whatever's in the listing agreement. If it's not the same amount that's in paragraph 7A, the buyer's rep, then the buyer pays the difference. Additional compensation. In addition to broker's fees specified in paragraph 7A, talks about construction and service providers. Same. Notice regarding bonuses or other compensation. This has been added. In addition to broker's fees specified in the paragraph 7A, seller, landlord, or their agent may offer broker other compensations such as bonuses. If client purchases or leases certain properties, broker will disclose the specific amount of compensation offered to broker. Broker may not receive other compensation unless authorized in writing from your client. And they've got the 1505 for that. So before we could get those BTSAs without anything, but now we have to get permission from our buyers before we can accept it. Yeah, and we can't accept anything more than what's on here. So if you have a listing and they're offering 8%, but your agreement was only for 4%, we can't accept the 8% unless we go back to our client, renegotiate, get it in writing. All right.
Mitch, what if
Yes.
client, what if on a BTSA by builders, this is where I've run into it, a builder is offering 4,000 or 2% bonus.
Yep.
The client says, you can accept it if you pay me half.
Okay.
Can we do that?
Yeah.
Okay.
Then it talks about protection period, same as it has been before. They just moved the paragraphs. Paragraph G is escrow authorization. It's just the broker clients authorizing escrow title to write checks for us. And then H, amounts payable to broker are paid in cash in Harris County. It's always going to be Harris County. It's where the brokerage is located, not where the property is located.
Mitch, I have a question going back to what she was just saying. If you've agreed to do something at a certain price, like on a lease. So you're taking and showing them, and I'm not sure how this is going to work with apartments, which was, kind of a question. So let's say you've got a representation agreement that you're going to make 50% or 100% of a month. And then you get there and they're like, oh, we've got a $250 gift card. Is there a form to amend your buyer's representation agreement that says on this property?
Yes.
Okay, so there's something that we can.
Yeah. TXR 1505.
Thank you.
Okay. Any questions about paragraph 7? Representation has not changed. Intermediary has not changed.
So I do have one quick question.
Yes.
So, because on the short form, it kind of talks about it. On the long form, it doesn't. So say that you have a client that you're kind of trying to decide if you're going to work together, because this is different than what we were doing before. I know that before, we've had buyers that don't buy. And so
Yeah.
you don't necessarily get anything from it. Is there a way in this to say, like, I will represent you and do my due diligence, but on this, it shows you only get paid if they actually purchase a home. Is there a fee somewhere that you can, is it later on?
I believe so. You could put in special provisions.
Okay.
Yeah.
But we are allowed to charge a fee.
You are allowed to charge.
Okay.
Yeah, it's opened up the box, so you can do so many different things. Some agents have talked about doing a retainer, and I charge X an hour. I charge X, and I'll show you 12 properties. I charge X, and I'll show you up to 20 properties. So it's up to us to kind of figure out how you're going to work your business.
But wouldn't that be practicing law to put that in special provisions if you're kind of changing that up a little bit?
Well, wait a minute here.
Okay.
Who are the primaries to this agreement?
No, client broker.
Right. So as a primary, you can make changes. All right, paragraph 13 is what all has been moved to paragraph 7. Still have mediation, still talks about default, attorney fees, limitation of liability, addenda that you may be attaching at this time. Remember, anything that you check off needs to be attached, given to the client, and then put into command. Paragraph 18, additional notices. A, that's the bold conspicuous that was removed to the first paragraph in 7. Talks about fair housing. You're not an inspector. Get an attorney to look at the abstract. Changed up just some of the verbiage in F as far as wire fraud, transferring of funds. They have added broker associates printed name and license number now. So you have to have the broker's number and your number as the agent, and it's on all the forms like that. Any questions about the buyer's rep?
I'm sure I'll have one, Mitch. And so just to be clear again, because I've got a couple listings maybe this weekend for stuff, and it's best just to push them till Tuesday till I get the form adjusted.
Not necessarily. I'd want to get them under an agreement when I'm showing them the properties. And
No,
then you
listing.
can amend it.
No, but listing. Okay.
I
Yeah,
would
yeah.
still want to get them under an agreement and amend it when you need to.
I have a question. I just posted this in the chat, making sure that I understand. So in the alternative commission arrangement agreement, you said it opens it up to you could do whatever you wanted to do. So let's say they say, I'm not paying a flat at 3%. I'm going to pay $150 for you to show me 3 properties today. And they sign the date of, June 20th.
Okay.
They pay that to Keller Williams? Like, how is the payment collected?
All payments, anything that we get in relationship to real estate has to be paid to the broker.
So in getting them to pay these funds, this is going to be complex, right? I mean, how do we invoice them and go after that?
So you're saying that they're not going to be, you're just going to be showing them properties?
I don't know. I mean, you said it opens it up to anything. So I'm thinking,
Right.
if they start calling around and go, I'll sign if we're required to have these. So for us, we always get these signed anyway. So I guess just not everyone gets them signed at the beginning anyway. So now you're saying it's going to be required that they have to have this before they show any properties, which is fine. But now the buyer is going to know or understand that they can call any agent they want to
And
and
negotiate.
say, negotiate. But then let's say even it's $1,000. If we never see this person again, how are we going to be able to collect that $1,000 from them?
That would almost sounds like a retainer. You'd have to get it up front, certified
But
funds.
it has to go through the broker.
Yes.
So they just write a check to Keller Williams Memorial?
Well,
Like, how does the
well-
DA work? You know what I'm saying? Like, how do we do that? I don't want to do that, but if someone
Right.
says,
we would
I'll-
have to talk to accounting with that. It'd probably be like a referral fee. That's what I'm thinking.
okay,
but
I'm not
accounting
trying
will
to
take
get
care
us
of that.
sidetracked. I just am trying to understand this concept.
Mitch, where is it that talks about the alternative fees?
It doesn't.
Okay, I didn't
It's
think I
just
saw
your
it.
fees.
Okay,
What are you charging?
Okay, great, thanks.
Mhm. Switch over to 1101. The listing agreement. Okay. Parties stay the same. Property has stayed the same, legal description. Improvements haven't changed. Okay, paragraph 5, just like in the buyer's rep, they've just pulled everything with compensation up. Same statement. It's all negotiable. So A, broker's fee. This paragraph 5A includes payment of compensation to the other broker working with a buyer. Seller authorizes broker to compensate the other broker as indicated below. So when earned and payable, seller will pay broker X amount. How much of that is going to be, and then how much are they going to be paying the buyer's agent? Any questions about that? So you can put your fee here and what you're going to be sharing.
Is that where we would put that if there's an unrepresented buyer? Where's that gonna go?
No, this is this is if they have an agent. You could put here on B.
Hmm?
Yep. Unrepresented buyer will be X% or whatever.
Okay, and Mitch, not wanting to make this too difficult, okay, when I'm explaining it to, my client. And I can tick A and put 3% or 3% of the sales price,
Mm-hmm.
and tell them that's what I work for.
Yeah.
And the 2 part is if we're going to help out the buyer, how much do they want to do?
Yes. Well, you're going to put, just like done before, it's going to be the total amount here. Of that amount, what is shared with the buyer's agent?
Okay, so the total amount goes in A1.
Yes. And
Okay,
of that amount, what's being shared with the buyer's agent?
okay, and just what it says, from amount stated in 5A, the broker will pay the other broker the following fees.
Mm-hmm. Okay. Really has not changed. Same thing it's been. This is the big change. B, broker's fee without compensation of other broker. This is how much are they going to do? They're offering 0 amount to the other broker.
When earned and payable, it says we'll pay broker, that says paid to broker only. So does that mean the listing broker or is that the selling broker?
On this is the listing broker. This is the listing agreement.
Okay, so if we have an intermediary,
Mm-hmm.
we are offering something different in pricing or guess because it's not even clear on paragraph A, B is where you would put in an intermediary situation.
No, you would still you're still going to do it. If they're not offering anything, you're going to put it in B, and then it's whatever's on the buyer's rep, buyer pays. Is that clear?
Right, on an intermediary, but this is also where we could put if there's an unrepresented party. That for me, my fee is gonna remain the same, like. If I'm charging 6% and then some dude, gotcha, and this guy who I can't wait to get one of those calls. That even though he thinks he's gonna be somehow he thinks he's saving money. That I'm still gonna get paid the same.
Yeah, that hasn't changed.
Right, okay, got it.
Now, if you have X% in there and unrepresented buyer, you can always do an amendment to it and say you're going to change it to, instead of 6% to 5%.
Mitch, would you advise that we have that in writing prior to that scenario?
I don't know. The
Is the last-
broker out of California was talking about never a listing agent never offering anything. Negotiate it once you get an offer.
Oh my gosh, that sounds so stressful. Hey, also in the last couple of videos that I've hopped on regarding how to be in compliance with explaining the broker compensation.
Mhm.
And at the beginning, I mean, I've been doing this for 10 years, and at the beginning it was, it's always been negotiable, yes, 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 but the total amount is 6%.
Mhm.
That's paid to the broker. In this case, the verbiage I'm hearing is sounding more like, what would you like to offer the other? Would you like to offer cooperative compensation? If so, how much? Which then kind of like the previous person mentioned, if it's an unrepresented buyer, we've talked to the seller explaining, what would you like to offer the other party?
Right.
And my fee is not actually a 6% or whatever number that is. It's half of that. But then if it's an unrepresented buyer, we're still gonna, like normal, collect 6%, but that might be misleading to the seller. I'm not sure if I'm explaining that correctly, or maybe if you have any other locations for scripts on that. If we're telling them, hey, I charge X, how much would you like to offer the buyer's agent for cooperative
Well,
compensation?
I charge X. How much of that would you like to offer the other buyer? If they
Okay,
even
so
want to.
yeah, so then we can say I charge 6%.
Yeah.
Okay, the last couple of classes sounded like I charge this, how much would you like to offer them? And together that's 6. Which sounded a little bit confusing if we're explaining that to the seller.
Yeah.
That way. Okay.
I'm a little confused by that also then, because I was told that I could not say that when I do this as a listing presentation, that I need to say, I charge X number to list your home. Would you like to offer anything to a buyer's compensation? And then you add those together. But in this new form, it would be 2 different numbers. So if I was asking, if I wanted to do a 6%, and I charge 6%, then it shows how much are you going to pay to the buyer. It's not necessarily taking it out of my 6%. It could be another 3% to the buyer, correct?
No, on this, it says of the above amount.
Right, on a B, on A.
Yeah.
Okay, so then you would say, I would say 3% for me and 3% to the buyer if I can get them to do that. But they're also saying on this, we cannot in any way encourage them to pay 3% to the buyer's agent. Is that correct now?
Well, we can't coerce them into it. We can go over it, and say, hey, these are the benefits of there being a buyer's agent on the other side. These are, the reasons, the benefits. This is how I'm going to market the property. You can't say that, well, if you don't offer, your property will never be shown.
You can't say that now. Okay.
No, you can't say that now.
I never said that anyway.
Never say that anyway.
Yeah, and if they say, I really don't want to offer that, that's fine. My fee is X.
Okay. Thank you.
Please go over B again.
Broker's fee without compensation to other broker. When earned and payable, seller will pay broker whatever your amount is. So that's all we're going to charge them, and nothing's going to be offered to the buyer's agent.
So we're either filling out paragraph A or paragraph B. We're not filling both. That's what I thought.
A or B.
Oh.
Yeah, complete either 5A or 5B only.
Can I have another water?
Then where again, how am I going to get compensated for this unrepresented buyer that I'm going to have to do all the work for? Where
Right
did
there.
that go?
Whatever you've agreed upon.
Well, where do I write it?
So you're saying you're going to charge more if there's an unrepresented buyer?
If there's not another broker,
Right.
I still get to keep my 6%, is what you're saying?
Yeah, it's always been like that.
Thank you. Never mind.
Okay.
it's just, this is so confusing, sorry. And this is my first class, so.
Oh, okay,
brand new.
go ahead, Kim.
Sorry, muddying the water again. So my original question asked, I have sellers who
Mhm.
said that they will offer compensation, but they want it based off what
Right.
offer they're getting. Where would I put that in there?
You could put it right here on B.
So just put
Well,
it on B.
actually,
Well,
you
because
d-
it doesn't really go on B. It seems like it would go on like number 2, but there's not
Mhm.
an extra space
there's
on
not an
Q.
extra space there. I would put it on B. Just write it all out.
Okay, I've got the.
Well, just like special provisions on the contract, it completes another paragraph. So you could put in special provisions and
Okay,
broker's fee is this with this to buyer's agent at this price.
okay,
Or attach something.
okay.
Can always do that also.
Thanks.
So, okay, now back to A2. So if the other broker represents the buyer, then I'm happy, let's give 3% to them. If the other broker is a sub-agent, now, if I've got this unrepresented buyer, am I acting as a sub-agent?
No, you're the listing agent. A sub-agent would be somebody coming, bringing an agent bringing the buyer to us without a buyer's representation agreement. Then
Okay.
they would be a
How can that
sub-agent,
happen?
and we want to offer nothing.
Right, but how can they do that now?
They can't.
So why is that?
Well,
even
I
in-
guess they could because they would be working as a sub-agent to the seller. Yeah, they would have to be given the representation agreement and understand they're working as a sub-agent, which they must get permission from the broker before you can be a sub-agent of the listing.
Got
Not
it.
if every buyer has to be represented by a buyer tenant rep. There's no way to be a sub-agent.
Well, it says if you're representing them, if you're not representing them, you're representing the seller. And you'd get written permission from that listing broker before acting as a sub-agent.
So confusing, Mitch.
That doesn't make any sense. I don't understand how you can have sub-agency when the whole point of this whole lawsuit is
Mhm.
about buyer's agency and how that works financially. How,
Yeah.
if you're saying that every buyer, before you open the door to show them a house or before you even give them a virtual tour, has to sign a representation agreement, how can you then have sub-agency?
So what if someone shows,
interject really
someone in
quick.
the office shows my listing? For me, aren't they a sub-agent?
If they're not from our brokerage, they're a sub-agent.
So not everyone is going to get the representation agreement like they're required to. So if they don't have it, it automatically makes them a
A
sub-agent.
sub-agent.
So
Mhm.
that's, I think, is what this is trying to let you know, is that somebody becomes a sub-agent because they didn't get that agreement. We'd love for everyone to get the agreements, and we're supposed to, but we all know that there's going to be people out there that are going to show houses that don't have an
Without it.
agreement.
Yeah. And the MLS and the MLS can ask for a buyer's representation agreement at any point. So in theory, we should not have sub-agents.
Yeah. Okay.
So when we get an offer on the property, if we're the listing agent and we get an
Mm-hmm.
offer, do we have to require that buyer's agent to present us with their buyer's representation agreement?
No. And we can't ask for it either because that's an agreement between the broker and that client. Again, we're going that everyone's abiding by the code of ethics and the lawsuit.
And we know that's not going to happen.
Yeah.
Mitch, would
Mhm.
you roll back up to that? Roll back up. I just want to make sure I understand it. Now, if I go to NAR, I can run this document off and look at it, right?
TAR.
Yeah. Okay. And the A part, the broker's fee. So just like it has always been, whatever,
Mhm.
we can put 6%
Yes.
in there. Okay. I'm explaining this as the listing. And then I come down and it's either going to be A or be. I just need to look at this.
Yeah. Okay.
Thank you.
Uh-huh. Earned and payable, only changes has been capitalized earned. Payable, same. Other compensation. Breach in the contract. Service provider, same. Other fees or reimbursable expenses. If you're charging them for professional photography, there's nothing says we can't do it à la carte. This percentage is for this. This percentage I pay for staging. I pay for this and that and other. It's up to us. Protection period's the same. F is still always going to be Harris County. We got the escrow authorization. 8, where it talks about cooperation with other brokers, has just been moved up to paragraph 5. And okay, here it comes. I'm not sure why they have 8 reserved on here. I don't know if they're considering adding something to it, but right now it just says reserved. 9, intermediary, still the same. Disseminate information about property to other brokers and to prospective buyers, including offers of compensation to buyers representatives and applicable disclosures. In this is 11F, this has been added. Seller does or does not authorize broker to share with other brokers and prospective buyers that seller will consider contributing an amount towards buyer's expenses, such as buyer's broker's fees, other closing costs. Seller is not obligated to pay any specific amount and has sole discretion to negotiate payments in the buyer's. This is them saying, yeah, I may contribute at this amount or that amount. They're not tied into it though. It's all negotiated once you get the contract.
So doesn't this in some way conflict with the other paragraph that we've just spent quite a bit of time
No,
on?
this is seller's contributions. This is the seller, they get a full
Brokerage
price
fee.
order or full price offer over. They may say, hey, yes. Or if they put no compensation, when it gets to the contract, they could negotiate it. Yeah, I'll contribute X amount to your buyer's cost because you're coming in at a full price offer.
But buyer's cost, not necessarily buyer's commission.
Right, it's buyer's expenses at closing.
And that's different because you cannot, that can be subject to the lender approving it.
You're right.
Got it.
Well, they still have a percent they can do. Like 3%.
Yeah, but they've gotten pretty good
I
at
thought
this.
the lender separated out that they put out that they're gonna say that
They won't consider
commission
it.
is not considered part of the
Okay.
seller contribution amount. Like say you can only get 3% on a conventional
Mhm.
loan. If it's 3%, you can get the seller to pay 3% closing cost.
Okay,
They can go like 6% because part of it goes toward your commission. And
awesome.
it doesn't all count. So you just have to make sure it appraises. That's what I've heard, but everyone can fact check me on that.
Yeah, it's all.
The same thing.
And
I
they put a letter out last week about VA.
Right. Okay, so I had one that they were offering 10,000 towards closing costs for a buyer. But when I did the numbers and I knew that the lender was not charging the buyer anything for the loan, that 10,000 wasn't going to be used.
Okay,
So what I did is I reduced the price of the house. Our offer was reduced to accommodate the fact that we could not accept that 10,000.
yeah, that's all the same.
Okay, that's
All
what this is all
negotiated.
about. That's what I
Yeah.
thought.
Okay. They took out 21A, broker's compensation, because it's been moved up to the top and it's conspicuous and it's underlined. And they've added broker associates license number. Okay. Any other question on the listing agreement?
Yes, you knew I would. I'm sorry. I'm going back to the broker's compensation on page 2.
Okay,
So if, in a scenario that was offered, and she says that she is offering, she's going to list at 6%. And
So
then,
Karen, why don't you give me a call after the class?
okay, great,
Okay,
thanks.
thank you.
Oh, I'd like to hear her question, Mitch.
So would I.
Okay. Go ahead, Karen.
I'm trying to,
You just muted yourself.
okay, I'm out. All right, so if they're offering 6%, if that's what I say to a listing, I'm going to charge you 6%. And then I say, would you like to offer anything towards the buyer's representation and or compensation? And they say 3%. So if I put in broker fee on box A, I fill in 1 as 3% on A, and then on 2, I put 6% as A, and I do 2 as 3%. Isn't that obligating the seller to pay 9%?
No.
How?
A1 is the total amount. 2 says from the amount stated in 5A1.
Got it. Sorry, I wasn't reading it. That's my mistake. Sorry.
Okay.
Yeah. Mhm.
They've also updated the lease listing, and it's the same. They've just moved everything like they have in the listing agreement. All right, 1404. Amendment to listing. So this is what we can use to make the changes. Owner means seller. They've just put in C, Texas 1101 or 1201. The broker's fee is changed to. You can make the changes here. Broker's compensation. So if you have one of those buyer's reps sign now, you can use this if it's not sold by August 17th.
You mean a listing agreement?
I'm sorry, listing agreement, right.
So it needs to be sold by August 17, closed.
Or at least under contract.
Okay. August 17.
Yeah. Okay. Seller's authorization to release, or I'm sorry, disclose and advertise certain information. This form has been pretty much totally updated. So you've got the property address. Seller authorizes broker to disclose and advertise the following information concerning the property to prospective buyers, other brokers, and on multiple listing services. That needs to be coming out. Well, not necessarily. Okay, never mind. For example, insert regarding amount seller would consider contributing towards buyer's expenses, seller's reason for placing the property on the market, any conditions of sales, or phrases such as terms are negotiable, bring all offers. And they took out that second paragraph. This is a really nice form. Is how many buyer's agents ask you, why are they selling? Yeah. Oftentimes, this is what we need from the seller to give out that information. And we shouldn't be given any information that we haven't gotten permission from the sellers for. Any questions about this form? It's not a required document. Highly suggest it.
How do you see that being used most often?
Why are they selling the property?
Yeah, I mean, that one thing, but what else would you use this for? I mean, how do you see this being used in real life other than why are they selling their property?
Well,
'cause
I've seen so often on the MLS, sellers are negotiable, bring all offers. Seller willing to negotiate contributions you could put on here.
Yeah, that's what I was sitting here wondering.
Mm-hmm.
This is where we would start using this.
Anything that seller is may entertain or gives you permission to disclose.
So if we are saying that the seller says, cool, I'll give you 6%, we'll pay the other person 3%. Would we put in here, is that where we would put seller would consider contributing towards buyer's expenses? Is that where you would, I mean, you couldn't put it on MLS, obviously.
Right.
But if you use this to say, hey, the seller will consider contributing 3% towards your buyer's agent expenses, or,
You could.
and then we could just do that verbally, I guess, because we're not allowed. Okay. Because MLS, you said HAR is going to have a box about, and Matt mentioned that the other day too, that yes or no, are there concessions?
Yeah, they're discussing it. I haven't heard whether or not it's been approved yet. The last meeting I was in, everyone really was for it, so we'll see. This is the representation disclosure. So when you have someone that does not want to be represented, or you're going to show your own property. Property address, broker firm name, broker associate's name with your license number. Talks about Texas occupation code. You know, have to treat everybody fairly. Broker represents the following party, seller or buyer. Real estate license holder, while acting as an agent, is a fiduciary. Primary duty of license holder is to represent the interests of their client. The license holder must treat other parties to a transaction honestly and fairly. However, the duty to their clients is primary. Was just thinking with it says that we have to disclose what we're going to get paid, but if we have someone who's not going to pay us, then you could also do this. You wouldn't have to have that full form. Best practice. The times I've seen this used now is usually with investors who give you a call about your listing. They don't want to be represented. They've done it 100 times. They know what they're doing. So this would be the representation disclosure and the IABS. Amendment to the buyer's tenant representation agreement. When did you go into it? When is this going to be effective? If you're updating the market area, so they've decided they want to look at Fort Bend instead of just Harris County, put it on here. The date agreement ends specified in paragraph 4. If you're going to extend your buyer's representation agreement here. Texas 1507 only. Broker's obligations under paragraph 5 is changed to full service or showing services. We're not talking about the 1507 at the moment. That's a short form and it really makes you a sub-agent. D, if you're changing the compensation. Purchases, leases, Texas. And here's where you'd put if there's bonuses offered. They're going to give you $1,000 BTSA. You put $1,000 here. Following property and the property address that it's being offered on. And then they have the same changes they've had before. Any questions about that? If you looked at this the other day, it was changed over the weekend. Okay. I don't think so. Yeah. This one they had left, they didn't have an amount in here. And when the lawyers looked at it, they said, well, no, it says that we have to have an amount. It can't be open-ended. So they put it on here. And they took it off of the buyer's rep. It was on there. But as soon as I said that, they'll probably change it. Compensation agreement between broker and owner. Unrepresented for sale by owner, for lease by owner. This is the form we would be using. So the parties, the owner, the broker, property address. What's the asking price? Who, registration, broker registers our prospect. What's the broker's fees? If it's a lease, same thing. Renewals, subsequent sale, the tenant decides to buy the property before the end of the lease. Broker will represent owner only, will represent prospect only, will act as an intermediary between owner and prospect. I don't like the wording there. If the broker acts as an intermediary, hasn't changed. This agreement supersedes any prior agreement between parties concerning the same subject matter. It's pretty much stayed the same on this agreement. Have y'all used this form? The agreement between
No.
broker and owner? We had several, and like I said, it's normally with for sale by owners. Don't want to be represented. Right, compensation agreement between brokers. It's taking me a little while to remember compensation. Now, if the other broker is paying the fee, this is going to have to be on all contracts. So listing broker, cooperating broker, property address. This agreement agreement begins on, ends on. When earned and payable, listing broker will pay cooperating broker blank percent of the sale, blank percent of 1 month's rent. Talks same thing about earned and payable. If a related party of a client, this used to be on the protection period, so it's been added. If a related party to a client agrees to purchase or lease all or part of a property during the term, cooperating broker will be entitled to all compensation. All right, that's new. So you can't have your brother buy it, still have to pay. And they've added license number for associates. I haven't seen this one used very often.
Yeah, but now we're gonna use it all the
Yeah.
time, right? We're gonna use that form all the time?
No, actually, I'm wrong on that because they did another form, a new form. We'll get to that in just a second.
Okay.
So that form is the one that we used with leases.
Between broker and owner? Yes.
Registration agreement, well, compensation. There was an agreement between brokers that went with leases.
With the
Mhm.
lease, yeah.
Yeah,
Is that this now?
yeah.
Okay.
So they've told.
Is that 2402?
That's 2402. 02. Okay, last one was the 2406. Addendum regarding broker's fees. So the address, this addendum controls any part of the addendum conflicts, okay. Cash fees as specified in this addendum will be paid in Harris County. Listing broker's fee, seller shall pay listing broker the fee specified in a separate written representation agreement. That's the listed agreement. Other fees, other broker's fees will be paid as specified below, and buyer shall pay any remaining. So if the seller was only offering $1,000, you put $1,000 here, backwards. Listing broker shall pay blank or percent sales price as contained in the separate written agreement. And seller shall pay. How much is the seller going to pay towards those other fees?
Wait a minute, let me just look at this.
Yeah, I've confused myself
I'm
here.
confused.
Yeah,
Mitch, did you say this was to be used after?
this is an addendum to the contract for broker's fees.
Addendum to the listing agreement,
No, contract.
contract, okay.
Okay, let's look at it. Other brokers' fees will be paid as specified below, and buyer shall pay any remaining amount due to other broker under separate written agreement. Okay. Listing broker shall pay blank dollars or blank percent of the sales price as contained in a separate written agreement. Seller shall pay okay, this would be if they're not offering anything on the listing agreement, then they'd agreed to. So how much is the seller going to pay? Blank percentage. This is only if there's no no written compensation.
Mitch, I have a question.
Okay,
Going back to the 2402, the compensation agreement, wouldn't we use that on all transactions prior to submitting an offer? That way we'll know if the seller is actually offering compensation or not. And
yes.
if in the event, then we would use 2406 if not, right?
I like using that. You're right, for before an offer is made. So you have it in writing.
Yeah, and then we would amend if they weren't. Is that right? Is that how I understand this?
I would, yeah, I would agree with you on that. They're saying, she's asking that, can we use this to get it in writing? So if I called and said, hey, will you offer this? And they say, yes, we send this over.
Before showing? Oh, my God.
Before you make an offer.
Well, yeah, right. I mean, it's just simultaneously makes sense, right?
Yeah, you gotta have
So
everything documented since we don't have it on the MLS anymore.
I would use that on every single transaction prior to submitting an offer is what I would do.
I would agree with you.
Okay.
But if, let's say your buyer is cash poor, it seems like you would want to do this before you show.
Well, the buyer will let you know whether or not they're willing to pay or not.
Well, if they don't have the money and we know that the sellers compensate us, then it seems like we would need this. I would want to know this in writing before I showed the property.
Yeah.
That's what I was thinking. I think that is going to be a very difficult thing to get agents to commit.
It is going to be very difficult. I would at least have it in writing. So if we got an email from them, you called them and then follow up with an email. You said that the seller is offering X percent. We have it in writing.
Then
What about for a builder? Like Lennar used to advertise 4%, and then you get there and they say, psych, it's just 3%. How do we get this in writing before the contract with a builder?
Use all your great negotiation skills.
So
That's hard because you know how builders are.
Yeah.
So before every showing, we have to send this agreement to the listing agent?
Not necessarily before every showing, but you're probably going to be doing a lot of phone calls.
Before submitting an offer. I mean,
Before
just so,
submitting an offer.
yeah, not showing unnecessarily, but just submitting an offer. That way you're defending your client as see fit and what they've told you, hey, I can and cannot afford this.
Well, I think though the other part of that is to find out prior to showing if any compensation will be submitted, because they're not going to pay anything. The buyer may decide they don't want to see that property. And at that point, I would send a note to the listing agent saying, because they are not, the buyer has opted not to see this property due to compensation to the buyer's agent. Can we do that, Mitch, or not?
I wouldn't. That sounds like a lot of work.
Well,
Tell them because they probably know that
you're protecting yourself in your buyer representation because we don't want you to think that you're steering them away.
I think
Yeah.
we're gonna have problems with steering.
That's what
And
we
they may
still have
like
to
the
document
house and,
everything.
yeah.
Yeah, we're gonna have some major problems with steering if we don't document.
Yes.
That's my thought.
Definitely.
So we've
Yeah,
got to be
steering
very-
has been the top discussion the last 2 weeks with NAR.
100%.
So
And like before, on your buyer's rep, in special provisions, they get put on there that they wish not to be shown any property not offering
Mhm.
compensation.
that would be a good idea.
Yeah, we've always done that.
Well,
Or
actually,
should have.
I've recently had the issue and the buyers have said, look, if they aren't, we can only pay this amount and we can't, you know, nobody wants to be let down, right?
Yeah.
But if it comes and it boils down to them not offering anything and they're having to pay our fee and anything additional, they're going to say, no, you know, please don't show me any more properties that are not offering compensation.
Yeah. But
So
they
Mitch,
say,
can you-
I only have X amount I can pay.
Yeah.
You could put that and that would be your fee, whatever that X amount is,
Yeah.
no matter what's being offered by the other side.
Mitch, can you do some kind of an email to us saying, this is what you need to say in special provisions if your buyer does not want to see properties not offering compensation or compensation less than? Can you give us the exact wording like you've done on a couple of other things for us?
Yeah, I think I have that. I can send it out.
Thank you.
I'm not at Keller Williams. Will I get a copy?
No.
Okay.
But as soon as you join us, I will help you out with that.
Thank you.
Come
Mitch.
join us. We love having people.
Yeah, I just don't have access. Okay. Go back here. Those are the big changes. Farmer and ranch contract has changed. We don't deal with that a whole lot. There's the name exclusion addendum for listing. This is if you're taking the listing and they say that if so-and-so purchase it, then you won't be paid anything.
So Mitch, I need to be very familiar with this 2406, 1501, and 1505.
Yes.
Okay, and that 2406.
1506 is general information notice to buyer seller.
Yeah.
They've changed one thing on there and all of that is contained in the Keller Williams seller's disclosure.
Okay. Would you bring up that 2406 again? That is going to be the one that we need before we make the offer to know what
But this
compensation.
one here is the one that's attached to the contract.
Okay.
It was the, which one was that? $2402 is the one you can use before the contract.
But the 2406 is going to be the one that's attached to the contract.
Yes. All right. So that's the last form I had to go over. Monday, Marilyn's gonna be doing the risk management. And she'll be covering all of these. At 10 o'clock on Monday, HAR has a Zoom panel discussion. I'm one of the panelists for that. So you can jump on there. We will schedule classes, some more classes in July going forward to review the same thing. Of course, after we actually get them and start using them, I'm sure we'll have a lot more questions and who knows, they may make some more changes. Yes, ma'am.
Okay, question. Okay, so these forms are coming out. Marilyn is talking next week and Har is talking. But what happens if we bump into agents that, you know, are using these forms in August? They haven't changed yet. Is there a date that we have to all change the forms?
August 17th is when it goes into when the lawsuit, the settlement has to be done.
Okay.
Okay.
The short form, we can use, I guess it's a broker, your broker would tell you which form to use, but it's an option.
Yes.
Okay.
There is the short form. With the short form, you're a sub-agent. So
Oh,
you're gonna have to be contacting that other broker to see if they compensate for sub-agents and if they even allow sub-agency.
oh, never mind.
Yeah. As a broker, I don't think I would want to offer sub-agency because I'm kind of taking responsibility for someone else's work that I don't know.
Right. It's just, they should have maybe named it a little differently.
Okay,
Thank
Yeah.
you.
no other questions? I appreciate your time and your questions.